All right. So as I mentioned, today's talk is about don't be afraid of estate planning. And again, just going to tell a little bit about myself and about my firm as we get into this. Owner and CEO of McClendon Law Consulting. I live in Macon, Georgia, with my husband and two daughters. Went to Mercer, went to Duke Law School, and my firm focuses on estate planning, probate, heirs, property, farm business, and succession planning. We've been doing that for about 8 years now. Me personally, my firm has been around for about five, but I've been doing this work for going on 9 years. It's something that I love. Been practicing for 14. My law firm is McClendon Law Consulting. We provide heirs property, estate planning, and probate legal services to help farmers, landowners, and other legacy driven individuals build wealth, increase their income, and secure their legacies. That is what we're about. No matter if we're talking about estate planning, heirs property, farmers, whatever it is that we're talking about, our goal is to help our clients to grow their wealth, to pass their wealth to the next generation, and to get more out of life. I really believe that through the services we provide, we're able to help people to go through life with more focus and more of attention to the things that matter, to help them to go about it more intentionally. And that's why we are here. It's not just about putting papers in place, but it's about enhancing your quality of life and allowing you to leave a legacy that blesses those who come after you. And so I asked you all if you could put something in the chat to just let me know, why you're here. I told you a little bit about why I'm here, but I also want to provide some context as to why this topic is so important and why it's such an urgent matter. I'm going to ask y'all a question that could be a little bit jarring initially, but when you think about it, it's so important that we all answer this question for ourselves. If you were to die today, what's going to happen to your family? What would happen to the property that you leave behind? Those unresolved loose ends that you have. What's in your email inbox? Do you want people seeing what's in there? Who's going to make sure that your bills continue to be paid so that those who depend on you can continue to benefit from what they've been benefiting from before? If you have a mortgage, who's going to pay the mortgage? Who's going to have legal authority to make decisions on your behalf if you are still here, but you are unable to make medical decisions for yourself, if you're not able to make financial decisions for yourself? And this is something that none of us want to think about, but it's what's even scarier is what happens when we don't have a plan in place. I met some people recently who work with families to help them prepay and pre-plan their funeral services. And they said that families have to make more than 75 decisions on behalf of a deceased loved one within the first few hours, the first few days of that loved one's death. And many of us have been through this our own selves to know when you have a loved one to die, there are so many decisions to be made. There's so many loose ends that are just needing to be tied up, especially if someone died unexpectedly. And so I want us today to really think about very, very intentionally what would happen if something were to happen to you today. Do you have people in place with the proper legal authority to make decisions for you? Do you have clear instructions to those individuals so that they know who is supposed to get what and at what time? Thinking about myself, I have minor children, little kids who, if something happened to me, I would need to know who's going to take care of them financially, who's going to continue to raise them and to instill the values in them that I have been trying to instill in them. Things like, if something happened to me, who would pick my kids up from school today? Those are things that we don't want to think about, but these are very real decisions that need to be thought through by somebody. And if we can put a little time and effort into making those decisions in advance, our loved ones won't have to make those decisions on the fly when they're already in the grieving process. So that is why we are here today. And I hope that if you get nothing else, you at least think about what would happen if these scenarios were to come about in your own life and how you would be able to instruct your loved ones on what you would want to accomplish. So if that resonated with y'all, if y'all could just let me know in the chat. It resonated with me, and I'm the one saying it because every time I say it and I think about how many implications there are to this, it just really like makes me pause and think, do I need to do something different? Do I need to make some changes? Do I need to have a conversation? So I hope that y'all are thinking about that as well. So a lot of people, when I talk to them about estate planning, they say, I don't have an estate. I don't really have much. And then when I start talking to them about what do they have, they realize they actually have a lot more than what they thought, and that they do need an estate plan because they have an estate. An estate is all the money and property that a person owns, particularly at the time of their death. It's not like something that only rich people have. And we're thinking about lush estates with all these buildings and houses and ponds and all this extra stuff. No, an estate is whatever money, whatever property you own when you die. And you need an estate plan to say what happens to your money and your property after you die. Who gets what? In what way do they receive it? If you have people you're caring for, like I mentioned, I have little children, or if you have a elderly parent or a sibling who has a disability and they depend on you, who's going to care for those people and provide for them financially if you are no longer able to do so? And then finally, estate planning deals with you while you're living, making those healthcare and financial decisions for you if you're not able to do that on your own. Who would have the legal authority to do that? If you ever have tried to call a doctor's office or do any kind of business for a family member who may have been sick or just not really wanting to handle that business, you know it's really hard to talk to anybody if you're not that person and if you don't have legal authority to act on that person's behalf. So it's important that we go ahead and put these things in place for ourselves now so that our family members are not scrambling to get things done for us if we became unable to handle our own affairs. So as I mentioned, estate planning typically involves planning for those personal assets. It also includes planning in the event that you become incapacitated, providing for loved ones who depend on you, and also planning for long-term care. People are aging, people are getting older and living longer now than they ever have. And a lot of times when we get into those later years, we may need additional care, whether through a nursing home or having someone come into the home. And if you've ever been through that, you know it's not cheap. If you've ever been through it, just put in the chat, it ain't cheap because many people have been shocked to see how expensive it is for them to provide for a loved one who needs some extra care at home or in a nursing home. And if you own land or a business, then your plan is going to involve a bit more. You got to think about what's going to happen to those business assets. How do you make sure that the way that your business runs, that it continues to run the way that you designed it to run? How do you pass on that know-how, that how do we get things done? You need to have that documented if you want your business to continue even beyond you. I know for me as a business owner, I created this business because I wanted to be not only a way of providing income for me and my family now, but I wanted to produce generational wealth that my family can depend on even into the future. I want my business to continue to be a blessing to my community after I'm retired, after I'm gone. I want this law firm name to endure. And the only way I can do that is by having a succession plan in place. So if you are a business owner, you need to have a personal estate plan, but you also need a plan for your business after you pass away or even after you retire. Let's talk about retirement sometimes. We don't want to just work till we die. We want to be able to have some time to rest and relax and reflect on life. And so we want to have a plan for funding that retirement and making sure that our business gets to the right people at the right time. So many of you may be wondering and I just want to say what was said in the chat. Someone said that they had to pay $4,000 for their father. I'm thinking a month for their long-term care for nursing home care. And those ranges can vary, but most of us don't have an extra $4,000 a month just sitting in the bank. So we need to make sure that we have a plan in place for ourselves and for our loved ones. Yes, 4,000 a month. This is not cheap. So the things that go into an estate plan: wills, trusts, business entity. If you have one, you want to have that plan in place. Advanced directive for healthcare, financial power of attorney, life insurance and other benefits, making funeral arrangements. All those things are the components of your estate plan. And we'll go into each of those with some level of depth. But one thing that I will just give you a heads up on: at the end of this, you'll have an opportunity to schedule a design meeting, which is a 1 hour meeting with me where we'll talk about these things, but we're going to talk about them specifically to you and your family. So what we'll do is talk through: what does your family makeup look like? Who's in your family? You got little kids like me, you got elder people who depend on you, or family members with special needs. We're going to talk about the options that we have and how you might structure it for your individual family. And then that's the first step that we're going to take toward getting your estate planning done. So if you are a resident of Georgia and you think you might be interested in that, please stay tuned so we can talk about how to get started. So first we'll talk about wills. A lot of times these days wills get a bad rap. People are just say, "Oh, I don't want a will. I need to get a trust." But it's important that we understand what a will does and how it works, because a trust can be a good option, but wills, they do have their place. So we're going to talk about wills now. A will allows you to create a plan for distributing your assets. It allows you to nominate someone to serve as your executor. It allows you to fund a trust or multiple trusts if you need to. You can nominate a guardian and trustee for your minor children. And then you also can continue your legacy of charitable giving. If you are someone who likes to give to a particular charity or charitable cause, then you can continue to do that through your will. But talking about distributing your assets, your will is going to control what happens to property that is in your name at the time of your death. So if you buy a house or you buy land or any other real estate, then usually you will be the person listed as the grantee, which means you're the person who bought the property or otherwise gained an interest in that property. And so as long as you are still listed as the grantee on that deed, your estate is going to control what happens to that property. So if you have a will, then your will is going to control what happens to whatever you own, whatever's in your name at the time of your death. If you do not have a will, then state law is going to make that determination for you. If you own property with someone else and you have what's called a survivorship clause, for example, it would say John Doe and Jane Doe as joint tenants with rights of survivorship. If your deed contains that special language, then that means that when one of you die, the other person is going to automatically receive the property. So if that happens, that's not the kind of situation that your will would control. That deed is going to override whatever you have in your will. So your will deals with any property that is in your name at the time of your death. If your property does not have any kind of survivorship clauses or transfer on death clauses or payable on death clauses, then that property would be controlled by your will. Your will can deal with money from bank accounts, personal property such as vehicles, jewelry, furniture. If you have life insurance policies, a pension, retirement benefit, and you have beneficiary designations, then those beneficiaries will get whatever you've left to them instead of your will controlling what happens to those assets. When you have your will, you can make either a specific gift, which means that I give my house to John Doe, or I give my land to my kids, Susie, Jack, and Jane. That would be a specific gift. You have a specific property and you're giving it to a specific person or group of people. You can also have residuary gifts where you could say something like, all of my property goes to my children, Susie, Jack, and Jane. Or you can say, all of my property goes to my heirs at law. And whoever your heirs at law are, that will be determined by state law. and it depends on who is alive and in your family at the time of your death. So we can do specific gifts, or we can do residuary gifts, and we can do that. We could do a combination of that as well if we need to. Someone asked, if you're purchasing property, how do you ensure the deed has rights of survivorship? So when you are getting ready to do the closing, before the closing is finalized, you want to communicate to the closing attorney. If you have a realtor, you can let them know, or you can just let the closing attorney know directly, hey, we want to purchase this property, but we want to do it as with the survivorship clause, so that if one of us dies, the other person will automatically get the property. Back in the day, not too long ago, but maybe before 10, 20 years ago, closing attorneys automatically would put it where the property would just go, like if a couple bought property together, they usually would set it up to where when one of the spouses die, their half of the property goes through their estate, and then when the other spouse dies, their half of the property goes through their estate. That used to be the default. And so with most people's deeds, when they purchase property with a spouse or someone else, then that property is usually going to be that way, where each person's estate is going to control whatever part that they own. However, now some closing attorneys are defaulting to the joint tenancy with rights for survivorship. And so if you bought property recently, for example, I know when my husband and I bought property about, I can't remember. It was within the last 10 years when we bought property together. They already had the survivorship clause set up. I was ready to tell them, but they already had it set up in there. So that's one thing to tell them in advance. But if you're wondering if property that you have already purchased has a survivorship clause in it, you want to just look at the words of the deed. That deed that you got when you bought the property is going to have a grantor, who is the person who sold you the property, and it's going to have grantees, who are the people who bought the property. And if it says John Doe and Jane Doe, grantees as joint tenants with rights to survivorship, or as joint tenants with survivorship, something that says survivorship, then more than likely it has that survivorship provision in there. Someone asked, can't bank accounts be exempted from being part of your estate if you name a beneficiary for payment on death? And yes, that is true. If you have a bank account and you have a pay on death beneficiary name, then whatever you die, your bank account will not go through your estate. It's going to instead go through to the people who are your pay on death beneficiaries. So that is true. And I just want to say one thing with setting up bank accounts. A lot of times people will create a bank account and they'll add someone on as a joint account holder for convenience purposes, so that that person can access money for them if they need to. I like to do that through a power of attorney as a preference, because a lot of times when the person whose account it was in the first place dies, then that other person who was added as a joint account holder just to help them out, they say, oh, well, this is my money now. And a lot of times there's nothing to show what the real intent was. And that can be a source of confusion and fighting for families. I've seen it more often than I would like to see. So yeah, y'all keep the questions coming if they come up. A will also allows you to nominate an executor to handle your estate. Your executor is the person that you appoint to carry out the terms of your will. I always encourage people to name a backup executor and to name someone that they trust. The job of the executor is to pay off the debts that the deceased person owed, distribute any assets that are named in the will to the beneficiaries, represent the estate in any court proceedings, and then if the deceased person owned any businesses, to carry on their business until you can get a permanent person in place. And once those things are done, they are supposed to close out the estate. It's not supposed to be something that just remains open forever and ever and ever. The thing that's very important to keep in mind with the will is that you're going to have to probate that will. It is a common misconception that if I have a will and I have everything laid out in my will, that I don't have to probate that will. That is not true. A will is always going to have to go through probate, and that's how it's designed. It's not a bad thing. Here in Georgia, it's not super expensive to do probate. It doesn't take a super long amount of time. In other states, it may be more complicated, but here in Georgia, it's not too bad. But some people still want to avoid probate because they want to maintain the privacy of the people that they have left things to, or they want to make things happen a lot quicker. Because if you probate a will, it could take 6 to 9 months to get that process complete. If you have a trust, which you're going to talk about in a moment, that transition can happen instantly. So it's something that a lot of people are considering now. They're looking into doing trust because they want that privacy. They want to save the time. They want the transition to just be a lot more smooth. But a will can be a good option if that is the route that is going to make the most sense for you. So now we'll talk about trust. A trust is a legal arrangement in which one party takes responsibility for the property or money or other assets of another person, and they manage it for the benefit of one or more other parties. There are many types of trusts that fall into one or two categories. One category is the revocable trust, and the other category is the irrevocable trust. But within those trusts, there's a lot of different types that could be created depending on your goal and what you're trying to accomplish. So to add a little visual that I hope will help, a trust works this way. You have trust property. It could be anything, money, house, contractual rights. It could be anything that a person can own can be trust property. You as the grantor or the settlor or the trustor, all of those are names that can be used. The person who originally owned the property and they want to put in the trust, they are the grantor, the settlor, or the trustor. They get somebody to draft up a trust agreement for them or a trust instrument, depending on how you want to call it. They'll get that person to draft it up, hopefully a lawyer that's going to make sure that it's done properly. So I encourage you to hire a lawyer to create your trust instrument or your trust agreement. The trustor, grantor, settlor directs the trust to be created, and they designate a trustee who is a person whose job it is to make sure this property is maintained, managed, and made available to the beneficiaries. So that's generally speaking how a trust works. You have trust property, you have a trustor, grantor, settlor who asks someone to help them to create a trust agreement or a trust instrument. They outline the duties of the trustee in there. They say what they can and can't do, and they name the people who will be beneficiaries in that agreement. So that's generally speaking how it works. One thing to keep in mind with estate planning, if you do a revocable trust and you're using it as a substitute for your will, the person who is the grantor, they're going to also be the initial trustee, and they also will be the beneficiary. So basically, you're creating a trust for yourself that is going to benefit. You're creating a trust that you're going to run as the trustee and is going to benefit you. But the thing is, after you become incapacitated, then a successor trustee will step into your place. Hopefully, if you become incapacitated, then one can step into your place. And after you die, then your successor trustee can step into your place. Your beneficiaries are going to change because after you die, you'll no longer be a beneficiary. And so that's where you might name a spouse or children to be your beneficiaries. And these are the kinds of things that you'll have your attorney to walk through this with you. And I'm saying your attorney. I hope that if you live in Georgia, that I will be your attorney. That is what this is all about. One, educating, but then two, letting you know how you can work with me if that's something that you are interested in. I would love to work with you. So there are many reasons you can include a trust in your estate plan. It could be for privacy reasons. Like I said, you may have a favorite niece that, you love all your nieces and nephews, but your favorite one, you want to leave her $200,000. And then the other nieces and nephews, they may get $10,000. or, more or less. I'm just giving examples. And you don't want everybody to know that you gave your favorite niece 200,000. They probably know you gave her more, but I mean, 200,000 to 10, they might be have a little issue with that. Not that they're going to be able to come to you about it because you'll be gone. It'll be something that they just fight about with themselves. Or you just may not want everybody to know that your niece got $200,000 because then when they need some money, they're going to be knocking on her door. So you can have a trust to have some privacy for the people you leave things to. If you have beneficiaries who are minors or disabled, you don't want to give them property outright. You want to put their property into a trust so that someone else can manage it for them. If you have beneficiaries who are what they call spendthrift beneficiaries, they like to spend their money, or they might take some chances that you may not necessarily agree with, or you may not necessarily think are the best decisions, but you still want to leave them something. You can leave it to them in a trust so that they will get a portion of whatever you leave to them at certain intervals. A trust can be used for asset protection, either if you are someone who is going to potentially need nursing home care, you may want to protect your assets from the state being reimbursed from your assets because they paid for your nursing home care. You might be a person in a high risk profession who wants to protect their assets from any potential liability if they got sued. A trust can also be used for tax planning. If you are someone who is a high net worth individual and you have above a certain level of assets at the time of your death, a trust can help your family members reduce their estate tax liability so that they get more from what you left behind. Also, a trust can be used to hold and manage family property. If you have property that is currently heirs property, you can change the heirs property into a trust so that instead of everybody owning the property directly, the trust will own the property and the family members will benefit from the trust. And then finally, as I mentioned before, a trust can provide for the automatic transfer of property from one person to another if a person becomes disabled or after they die. That property can be transferred automatically without there having to be a court involved in that process. Someone asked if assets will be protected with both types of trust or only an irrevocable trust. So with that question, the answer, the main answer is only an irrevocable trust would protect assets from various scenarios. However, most people who create revocable trusts will also create sub-trusts that will become irrevocable. So, for example, I might have a revocable trust that is active while I'm alive. I'm serving as the trustee, and I have it set up so that when I die, then I would want a portion of the money set aside for my children to take care of them. When I die, while I'm living, that trust is revocable. So that means that the assets are not protected because right now they're still kind of under my care as the person who created the trust. But after I die, since I'm out of the picture, the assets are going to be protected for the people I left things to. So as long as I'm here, then those assets are at risk for any of my personal liabilities. But after I'm gone, then those assets get transferred to my loved ones, and then they're protected for them from any liabilities that they may experience. And so it's kind of like the trust has to be irrevocable in order for those assets to be protected. And what that means is that the person who is benefiting from the trust doesn't have the right to change the trust. So if I have the right to change the trust, those assets are not protected because it's like a creditor can say, hey, you owe me money. I need you to write me a check from your stuff and pay me my money. But if it's an irrevocable trust, they say, hey, Veronica, you owe me money. Oh, you don't have property in your name because it's in this trust and somebody else is over. You have no control over those assets. That's an irrevocable trust. And that means that the assets are protected. So I hope that explains things that usually the trust has to be irrevocable, but a lot of times people will create a revocable trust that has irrevocable trust components that come into play after that person has died. All right. So, and you're welcome. Glad to be able to explain. So, the next thing we talk about in an estate plan is an advance directive for healthcare. It allows you to express your healthcare and treatment choices in advance in the event you become unable to communicate those choices yourself. So, you have your durable power of attorney, where you get to name someone who can make decisions for you if you can't. In that, you also have a living will, which is where you state your treatment preferences if you became either terminally ill or permanently incapacitated. That's not what it's called. Permanently unconscious. Then you get to state what happens under those circumstances. And then there's a part 3 where you get to nominate someone who will serve as your guardian if a court were to need to appoint a guardian. And this is something that it doesn't happen often, but I see where it can start happening more. I saw a post the other day where someone was representing a person who the person was sick and they were disabled. They couldn't handle things on their own. And their family member was trying to like talk with the Social Security Administration concerning their Social Security benefits. And the Social Security Administration said, you're going to have a guardian. We can't just talk to you, even though you're their power of attorney, because we don't know if that power of attorney is valid. The only way we can really talk to you is if you go to court and have the court appoint you as the guardian. That process can be kind of hefty. It can be kind of expensive. However, if you nominate your guardian in your advance directive for healthcare, that can kind of shortcut some of the process to make it easier for them to be appointed to handle business for you. So I hadn't seen that before, where I see a more common scenario that could come up where people would need a guardian and where they would need one kind of quickly. But I thought that was a good way to see where nominating a guardian in advance can be very helpful. Financial power of attorney is another document that we encourage everybody to have. It allows you to select someone to handle your finances if you are unable to handle them yourself. And you get to determine what aspects of your finances they can handle. The thing that's very important for everybody to keep in mind is that with the power of attorney, it ends when you die. So a lot of people think, oh, well, I'm so-and-so's power of attorney. And it's like, but they're deceased. So you are not their power of attorney. It ends when they die. That's when you're going to have to if you need to handle something for them, they're either going to have a trust in place or you're going to have to go to probate court to be appointed over their estate. But that power of attorney is going to end when the person dies. Your estate plan also may include life insurance and other benefits. And then what I want to say here is that it's very important for you to make sure your beneficiary designations are up to date. You don't want to be leaving your ex-spouse that you divorced 20 years ago. You don't want them to be on your insurance policy still set up to collect from you after you're gone, or your retirement benefits, whatever it may be. So you want to make sure that you review your beneficiary designations and make sure that they are still up to date. And I do also want to say with retirement benefits, I know that in the event of a divorce, there may be some situations where your former spouse will have a claim to your retirement benefits. I'm not talking about that. That's something y'all got to talk to your family law lawyers about. But what I'm saying is you just want to make sure that your beneficiary designations are up to date on all of your various policies and benefits so that you are making sure your funds are going to the right people. Another thing I want to point out is if you have minors that you are trying to leave life insurance benefits to, you need to either leave it to them in a trust. So you might have an estate plan with the trust, and you might have a special trust for those minor children. You want to name that trust as the beneficiary and not the children themselves. So you might have your revocable trust, and you might have a sub trust in there so that after you die, a portion of your assets go to your child, Jane. It'll be a sub trust created for Jane. So when you write your life insurance policy beneficiary designations, the beneficiary needs to be the trustee of the sub trust for Jane, or whatever the name is. And your attorney can help you we will be able to help you to kind of get that written up in the right way. But you don't want to leave it to the children directly if they are minors, because minors cannot inherit property. at least in the state of Georgia. So you would have to have a trustee, a conservator, or a custodian. You also could, leave your life insurance benefits to someone as custodian for that minor child. So you'll say the beneficiary is Jack Daniels, the custodian for Susie Daniels. You can do it that way. But again, you might want to talk with an attorney to make sure you write it out the correct way. But the main point, all that rambling to say, don't don't name minor children as beneficiaries on life insurance policies. So if you die without in a estate plan, what happens? Your property is going to be distributed to your heirs at law, and that's determined by state law. So here in Georgia, if you die and you're married, you have children, your spouse is going to get either one half if you only have one child, or they'll get they'll get 1/3 if you have more than one child. Your children are going to split the other 2/3. So it doesn't matter if those children are by that spouse, they're all going to share this property together. So if you don't have a plan in place, that house that you and your spouse bought together, and you don't have the survivorship clause in there, then your spouse is going to have to contend with your children for your previous relationship to get their share of that house. So you want to make sure you're mindful about that and have a will or trust in place to prevent that scenario. A judge is going to appoint who administers your estate, so you don't get to name that person in advance. A judge determines who takes custody of your minor children, and they're also going to appoint someone to manage assets or money that your children inherit from you. Or if you have a disabled family member, it's the same scenario. A judge is going to determine what happens to that person and what you leave to them. When you have a plan in place, you're in the driver's seat. You get to decide in advance how things will go. You take this burden off your family, and it helps you to maximize the value of the assets that you pass on. Finally, it allows you to leave a legacy that outlives you. You're not just leaving things up to chance. You're actually creating a plan for how things will go. And so a lot of times for people, like I talked about before, estate planning is a scary process. It's something they want to avoid. And I say, let's flip it. Instead of us avoiding estate planning because it's something that we feel like we got to get over, why don't we see estate planning as a gift to the people we love, to our communities, to ourselves even? So if we see it as a gift, what I mean by that is establishing your goals in advance, creating an inventory, selecting your fiduciaries, and assembling your team of advisors. So this is something that you can think about on your own. But when you are working with our firm, we are going to talk with you about all these things. So the first thing I'm going to ask you when we meet for a design meeting is, what are your goals? What are you wanting to accomplish? And then we'll talk a little bit about the people in your life and the things that you own. And then we'll talk about who you want to be in charge of what. So that's what we're talking about when we're seeing estate planning as a gift. So establishing your goals, we want to begin with the end in mind. What beautiful picture do you want to paint? And then we can talk about, how do we paint that picture? We need some blue, we need some yellow, we need this little circle brush, we need this big fluffy brush to create that picture. We want to cast a vision so that our beneficiaries, the people we leave behind, can pick up the torch where we leave off, and they can keep running without a misbeat. We want to think about who, what, when, where, and how when we are establishing our goals for our estate planning. We want to create an inventory. A lot of times people think they don't own much, but then when they make a list of what they own, they realize they actually own a lot. So we want to make an inventory of what we own: real property, cash and bank accounts, investment accounts, if you own farm equipment, vehicles, business interests, personal property. Make a list of everything that's important to you that you own. Now, I'm not saying that you say, I got my yellow shirt, and I got my green pants, and I got my brown shoes, unless those are like your favorite green pants and you want this specific person to get it. Otherwise, you just say clothes, shoes, whatever you need to do. But making this inventory can be very helpful, not only for you as you gather your thoughts about how you want to set your plan up, but it also can be helpful for your loved ones. Because can you imagine someone has died and you're like, I don't even know where they bank. Like I'm thinking about this for myself and people in my life who I might end up having this responsibility for. Do I know where they bank? Do I know all of the real property they own? They may have bought a little cottage that they didn't tell me about, or they may have inherited some property that they didn't tell me about. What about investment accounts, life insurance policies, like all the things that a person owns? They could be scattered all over the country or all over the world. Even I got clients who own property in Jamaica and Saint Croix, like all over the world they own property, and we got to make sure we have a good list of it in one place so people can find it. So creating an inventory can be very helpful for you as you are creating your estate plan, but also helpful for your loved ones when they're trying to get a sense of where things are. I once had a client long ago, not long ago, but several years ago, who died, and she was like, everybody counted on her for everything, and nobody knew how sick she was, and she just died suddenly as far as everybody was concerned. She handled everything for her family, like her grandparents' descendants, and for her home. And when she died, they had to go through bags and bags and bags of stuff because she just had everything in bags. I mean, we're looking at bags, we're pulling out Macy's receipts, grocery receipts, gas receipts, and then somebody's death certificate. We're pulling out deeds to property, all this stuff in bags. And the family was, it took several months before they could get a handle on that. So we want to make sure we have a plan and have everything laid out. Selecting your fiduciaries. You want to make sure you put the right people in place to manage your plan. And so that's your executors, trustees, legal guardians, agents. We want to make sure we name those individuals. Before you talk with an attorney, you may not know who will fill what role, but you can start thinking about, who do I want to make financial decisions for me? Who do I want to make medical decisions for me? Who do I want to make decisions for, who to take care of my children if I'm not able to? You can start making that list. And so then when you're meeting with your attorney, you'll know what you need to, what you'll have some ideas already in mind. Assemble your team of advisors, people that you need to help you create your plan. So definitely your attorney, but you may also have financial advisors, insurance agents, people to help you with planning out the use of your land after you're gone. If you have any business consultants, all those people, and there may be others who you would need to include on your team and have them talking with each other and talking with you to help you create a plan that's going to make sense for you. So you may be wondering, can I just do it myself? And if you think you can do it yourself after all that stuff I just talked about, kudos to you. But I don't advise people to do it yourself, even though you can. It's too many pitfalls that you could face. And as an attorney who's probated many estates and who's helped people plan many wills and trusts, I can kind of anticipate some of these pitfalls, and then I go and talk to other attorneys and we share stories with each other. So I can help anticipate these things and help you put a plan in place to prevent it. There's lots of true stories of things that I've personally witnessed. We have people losing their family property due to mortgage foreclosure. We have people who died thinking they didn't own anything, but they didn't know that their cousin left them a huge life insurance policy. And so now, even though they didn't own anything when they died, this other person who died left them a lot. And now, because they didn't have an estate plan, we had this whole crazy process. I mean, there were minor children, there was baby mamas involved. Let me not say that. There was children whose mothers were not married into the family. Now they are having all this say about things. It was a lot of mess that the family had to fight over. And we could have prevented that with an estate plan. We have had situations where people create a beautiful trust with all these details, but they didn't transfer the assets into the trust. And that's why it's important to talk with an attorney about the importance of funding your assets and how to get that done. And then we've had people who lose their family assets because of a long-term care placement, and they didn't have a plan in place to pay for that long-term care. So these are true stories that in some ways have been a horror story. Thankfully, we've been able to kind of get some of these resolved in a peaceful way, but we want to help your family to avoid even being in these situations in the first place because you have a solid estate plan in place. So we want you to choose an attorney who is an estate planning attorney and who can advise you in specific situations that you may be experiencing. We want you to choose someone you're comfortable with, someone that you can tell all your business to, because we're going to want to know all your business. And if you're not comfortable, you're not going to tell us everything we need to know. Choose someone who understands your personal, familial, and cultural values. Everybody don't see property and estate planning and family the same way. So you want to choose somebody who aligns with the way you see things. So when you're working with us, we have two approaches. You can either have a trust-based plan or a will-based plan. And within the trust-based plan, we have revocable trust, and then we have the irrevocable trust for someone who's planning, anticipating that they may need to go to a nursing home or have someone come into their home to care for them. And we have plans that are designed to help them protect their assets and make sure that they are eligible for long-term care. Each of the plans include a will. They include an advance directive for healthcare and a financial power of attorney. With the trust, we also have the trust, which is the foundation of the plan. And that will is just there as like a safety net in case the trust, for some reason, doesn't work out. And so some of you may be wondering about pricing. I know that that's a question a lot of people ask, and I thought I would just be transparent about our pricing up front. For some people, price is going to be a deal breaker, but I hope that for most of you, that hearing what we talked about and the different situations that could come up, that even though the prices may be what they are, I'm hoping you see the value that this kind of planning can bring in providing your family with peace of mind, and then also helping to just protect assets that would be worth far more than what you would be investing in creating a plan. So these are our prices for our estate plan services. We want to make sure everybody has something in place. So we have the safety net plan, which is a very basic will, where basically you name an executor and you say everything I own goes to my heirs. And we keep it very simple. We don't name specific assets. But then we have more complex planning that might be designed for protecting your assets from Medicaid, from a estate recovery if you have to utilize Medicaid for nursing home, helping your family to get more from what you leave to them. So here are our pricing, just so that you know. I don't want you getting on the call with me and then I talk with you about pricing and you feel like I blindsided you and you didn't know. So this is what we have in terms of like the full cost. To get started with us, you would schedule a design meeting, which is $400. And that's that 1 hour meeting that we will have where we're going to go through all kinds of questions. We're going to have you complete a very detailed questionnaire in advance. And then we're going to talk with you about what plan we recommend. So we would go to this list and we'll say, hey, based on what you told us, we believe this would be the right plan structure for you. This is how we're going to set it up. These are the people we're going to put in charge. And then from there, we'll draft your documents for you. So if you schedule with us a design meeting before the end of the week, we will apply the $400 from the design meeting to your plan. So it'll be deducted to the total cost. If you schedule your design meeting before the end of the week, then we'll make sure we make a note to have that ready for you. I am trying to remember what else I was going to say. Oh, so yes, you will do the design meeting with us. We'll talk with you about the plan, and then we'll get you signed up to create the full plan. And you may be wondering, is it worth it? Before I get to that point, I want to scroll through here, tell you how to get started. You can scan here this QR code to schedule your design meeting. And here's a link here, and it will also send you something in the email where we can tell you about how to schedule as well. I'll send that to you after this meeting. But I want to just, go back a little bit to talk about, is it worth it? And talking about things from the perspective of our past clients. If my little slides will let me go back. So we work with many clients in estate planning, and these are the stories from people who felt like it was worth it to make this investment for their families. We had Michael and Linda, who they believe that we were able to help their loving family stay a loving family, that we're going to be able to help their loving family stay a loving family through helping them to put estate planning in place. One thing that they told us when we were working with them is that people think this is easy. They think it's something that they can do on their own, but it's really something that requires an attorney who understands your family dynamics and can help you create a plan that makes sense for you. RJF talked about how we helped her family to understand their rights and do everything that we could to help them maintain their ancestral land. And we had a lot of different generations involved, and we were able to navigate some of those different issues. And we talked about theirs was dealing with heirs property. So heirs property and estate planning go hand in hand, and we were able to help them through that process. We have other clients. We have Tracy, who gave some feedback for us, and Michelle and Jessica. And so we hope that we can add your name to this list of people who are past clients who are satisfied with the services we provided, either from a planning perspective or from helping their family to resolve issues. So I am going to go back to the link to schedule. We would love to work with you. You can, I also will give you the privilege once we send you the follow-up information from this webinar. We will give you the privilege of sharing it with a friend or a family member. And if they decide to schedule a design meeting with us before the end of the week, we will also apply their design meeting fee to the total cost of the estate plan. So that's something that you can do as a gift to those you love so that they can also benefit from this. So with that being said, that is the end of the webinar. I'm very grateful to be here with you all today. If you have questions, I can hang around for a few more minutes to answer any questions, and just let me know how our firm can help you. If you need to reach out to us later, you can do that as well. I will say I'm going to post a link for a 15-minute call if you are still just having questions about the estate planning process and you're not quite ready to schedule a design meeting. We do have a 15-minute call where you can talk with our intake specialist, and she can help you get started to help you answer some just general questions about working with our firm and things like that. So if y'all have any questions, I'll hang around for a little bit more to answer those questions. If not, I hope you have a great rest of your day, and I hope that we can work together on your estate planning or something else in the near future.